Way here. So as you all know, you're in the February 2025 Care Coordinator Info Share. Today we have a special topic with Alex Royd, and he is from the Alaska State Commission for Human Rights and is going to be giving you a overview of what their team does, what they can do for you. I'm going to ask you all to please make sure you're muted. You are welcome to chat into the chat questions. We'll pause if necessary to let Alex answer questions as we go. If you have questions that are not related to this presentation, please hold those, email them to us, and we will circle back to you and address your concerns that way. So without further ado, Alex, what do you have for us today?
Thank you, Delight. Well, like you mentioned, my name's Alex Reuter. I'm the Special Projects Attorney with the State Commission for Human Rights. And here, I'm just going to come to you all today and let you all know, A, what the State Commission for Human Rights is, B, how it can help you, and C, what the civil rights and anti-discrimination laws currently are in Alaska. And as I'm going, if any of y'all have questions, feel free to throw them in the chat, and Delight's going to flag me down as I'm going. Here to answer any and all questions you can have on the topic. That's what we're here for. So without further ado, I'm going to get into just sort of a general, if I can press the button, maybe, hold on. There it goes. All right, sorry about that. So again, like I said, who are we? I'm with the Alaska State Commission for Human Rights. I may call us ASHR as we're going because the full name's a bit of a mouthful. Human rights is kind of a misnomer. Really what we do is more equal rights. The thing is that we were started back in 1945 before the civil rights movement really started getting going, and they didn't really decide what they wanted to call it yet. So we're stuck with human rights until the legislature changes it. Our mission is to eliminate and prevent discrimination for all Alaskans. We're made up by 7 commissioners. They're appointed by the governor and then confirmed by the Senate. Currently, those are Zachary Gottschall, Mae Marsh, William Craig, Jesse Ruffridge, Becky Carrillo, Sheila Cernich, and Doreen Lorenz. And we enforce something called AS 1880, which is the Alaska Human Rights Act. It basically lays out a bunch of categories and circumstances, and it says, guess what? You can't be discriminated against under this, and if it happens, you have someone to come reach out to, and that's us. So we investigate claims of discrimination, we conciliate and present cases at trial when discrimination has occurred, and we advise the public on state of discrimination laws and conduct training and whatnot. We're the civil rights agency of the state. So today, what I'm going to run you through is sort of, again, who we are, what the law is, and what is and isn't discrimination. I'm going to talk about 2 big areas of law that are changing on this currently, and that is around service animals and pregnancy discrimination. These are big topics, and things are changing at both the state and federal level. So I just want to sort of highlight what that is for y'all. And then I'm going to just, have some links if you want to look into this further. If you have your own questions that I'm not answering, where to go and what to look for. So again, like I said, ASHR is the civil rights enforcement agency of the state. If someone gets discriminated against in an area within our jurisdiction, you can file a complaint. You can call, you can email, you can knock on our door, you can write a letter, whatever. You come out and you say, hey, I was discriminated against because of, and you have to articulate a class. So you can say, because of my race, because of my age, because of my pregnancy, whatever. And then you say, in this instance that ASHR has jurisdiction over, and we'll look into it. We have a team of about 12 investigators out. They look in, they get your information, they get everyone else's information. We have subpoena power. Sometimes we're pulling security cams. Sometimes we're pulling email chains. Sometimes we're sending people out to go take pictures of, if there's a ramp or not, whatever it makes sense. They're bringing it back to me. If it looks like something happened, they'll kick it on up to my side of things, the attorneys, we call it the hearing unit, and we'll begin negotiations with the other party to sort of start working through and get make-whole relief. If, negotiations fail and we need to go further, we're going to take them to hearing, and if not, take them to trial. Did you have a question for me, Delay?
Yeah, in the chat. Sarah's asking how this work is impacted by the current executive orders.
Of course,
Has that been impacting
I
you?
get those questions all the time, and the answer is nothing yet. So I am a state agency. I am written into the Alaska State Constitution. It was so important. We're all the way at the top. Article 1, Section 3 of the state constitution says that you can't be discriminated against because of race, class, but it lists a couple. And then part 2 of that clause says the legislature shall enforce this, right? So it basically is including in the constitution that it's not enough that there are rights that you won't be discriminated against. The legislature has to find a way to make sure that you are able to enforce those. And as it stands, my agency is the one who is charged with doing that. I can't get fired by the legislature. I can get fired by the commissioners if I fail to do that. But like if I sue the wrong person, that can't get me in the trouble. And I can sue the state government, the local government, uh, and I do with some frequency. And we cause problems. Maybe our biggest instance was back when you may remember when Don Young died, and there was a quick sort of snap election. This was during COVID. They decided to do a primary with an all-mail ballot, right? All the ballots were mailed out, and we got calls from a couple blind people in Alaska saying, wait a second, I can't vote on an all-mail ballot. I can get someone else to sign for me, but now I can't vote private just like anyone else. That's discriminating against me by a practice of the government on the basis of my disability. We said great, and we stopped them from running that election for a bit until the Supreme Court sort of got mad at us. But different issue.
So the
Yeah, sorry,
follow-up, which is kind of in that same thought, is disability considered a protected class under Asher?
That's a great question, and I'm going to cut right it over to the next slide.
Perfect.
So we have a few different groups. Basically, so long as you match one of the first columns and the other columns, this is what I currently have written down protections over from the legislature, right? Those are employment. So if someone treats you different in your job, and that includes hiring, that includes firing, that includes promotion, that includes what wages you're getting, you can come to me, right? Financing. We don't get a lot of financing cases, but it was a point of some concern, especially back in the 70s. You would get cases where they would be like, come bring your husband down if you want to get a loan. Doesn't happen as much anymore, but we still get them from time to time. State or local government policy, right? So if this is, local regulators, this is, public school boards, all sorts of stuff, you can bother me. Housing, that includes rental of, not just houses, but also, apartments, hotels, if the stay is long enough, homeless shelters, nursing homes, things like that. And places of public accommodation. So that's businesses or what that you would walk into. If you walk into a restaurant and they say, hey, I'm not going to serve you because of your, sex, you can come call me and we can get that sorted out. And so we have protection in all of these areas if it's discrimination on the basis of race or ethnicity, national origin, religion, sex, or physical or mental disability. And we define disability very broad. You can basically come to us with, if it's in any form of the DSM or anything like that, I can take that case. Then we have discrimination coverage in limited categories on the basis of age. I can take that case in employment and housing. I'm hiding my thingy from myself. Marital status, I can take that in basically everything but government practice. Pregnancy, same situation. Parenthood, same situation. And sexual orientation, we currently have coverage in employment, but there is some, I don't want to say this, movement on that. So we shall see how it goes going further. And sexual orientation also includes within it gender identity. We have some it's called per se discrimination. Basically, if we see that this is happening, we're like, yep, that's it. You don't have to do anything else. Your employer is in the wrong. And so for this sort of thing, it includes not allowing same-sex spouses at other type of events, not providing, gender affirming uniforms, usage of preferred names, things like that. That'll always get you in trouble. But these are the coverages that we have right now. So as you asked, yes, disability is 1000% a protected class, and it is the #1 growing area for our cases. It's not the most cases we get. The most cases we get are typically some form of sexual harassment in employment, but over the past decade, what's been growing the most has been disability cases, especially service animal related cases. You have any other questions for me, Delight?
Yeah, I'm asking a qualifier because there was an ask about what about class? So I'm asking, do you mean economic class? As far
I,
as
I think I probably said class. I meant class is as in protected class, so it applies to race, national origin, religion. I don't have coverage over economic class.
like
However,
socioeconomic as a protected
yeah,
class.
yeah, sometimes that ties into it. And so as we'll get into some of the stuff, this isn't just a sign that says, you know, women can't come in here, whatever. This is anything that could have different impacts, right? So whenever we talk about discrimination, maybe this will clear some things up. There's basically four general types of discrimination that we look at. One is called disparate treatment, which is because of a protected class, someone is treated differently and put at a disadvantage, right? So this is usually something very explicit. You know, we don't pay women as much as men. I take cases sometime that'll have dress codes. It's not necessarily discriminatory to have gendered dress codes, but sometimes if one is way out of bounds and they're like, and men have to have pants on. And then the women will be like about this long. I take those cases with some frequency. That's disparate treatment. You're being treated different on its face because of your class. On the flip side, there's something called disparate impact. These may not seem like they're going to negatively impact, a protected group, but by their impact, they do, right? So there'll be, job sites that'll say no headwear. You can't have hats on, and they apply it across the board. And then someone says, wait a second, I have a yarmulke, I have you know, um, a headscarf, something like that. Well, now you're disparately impacting the religious practice of certain religious groups. And now I can get that. Same with no dogs policy. I enforce these all the time. They're like, oh, sorry, this apartment is no dogs. You can't have your services support animal in here. No, that's now treating people with a disability that may need that service animal or support animal differently. All right. All that impact is disadvantaging that group of people with a certain disability. And as such, now it's discrimination. I can take that case. On the flip side, there's also two other groups, harassment. So this may not be any particular instance. It's you don't have something that you can feasibly point to and say, I'm being treated different because of this. But it is certainly like unwelcome contact based on one of your classes. Typically, we're getting these cases in the case of sexual harassment, but occasionally we get cases for racial or gender identity harassment. It doesn't have to be a pattern for the record. It can be an isolated incident. If it's severe, oftentimes for the cases I get, this is about like sexual advances in the workplace. Obviously, that's inappropriate if perceived that way, and you can come to us and we can work through with that. It can come from supervisors, coworkers, customers, so long as you make it known and it's not taken care of. Now it sounds like you could be treated different in your job because of your, like I said, race, gender, whatever. And then there are a few odds and ends regulatory requirements that we have to enforce that may not necessarily seem as discriminatory, but are sort of under our purview because they affect a particular group. These include things like the
I'm
Pump
on
Act.
that call now.
Oh, sorry. The Pump Act, and basically requiring that there be a place to pump breast milk in a workspace. That may not be inherently discriminatory, but it's covered under our pregnancy protections. So failing to do it will be considered a pregnancy discrimination. How you like that, Delight? Any other questions? Right on. All right.
Yeah, you're
So
good to go.
here's a terrifying flow chart, but I swear it's not scary. I just want to let y'all know what happens when you reach out to us if you run into some of these issues. Basically, someone calls us, immediately goes to an investigator. If you say, well, it goes to the front desk and you say, hi, I've been discriminated against. They'll say, hey, wait 1 second. They press a button and you go to an investigator. From that point on, everything you say is confidential and anonymous. I don't have to give that out to anyone. All right. they'll listen to your complaint. And so long as, like I said, all you have to do is articulate basically two things. You say, hey, I was discriminated against because of a protected class. So, like I said, you say because of my race, my sex, my, disability, my age, my religion, whatever. And it's in one of the areas that we protect. I used to say just two, and then people started calling me from Canada. And so now I have to be clear. It also has to happen in Alaska. So long as it happens in Alaska and you're discriminated against because of a class and because of one of those areas, employment, housing, financing, places of public accommodation, or government practices, then I can take the case. Let me clarify. We're also a government agency, so this is all happening for free. We aren't charging you. At that point, you'll give your information, you'll say what happened to the investigators, and then you don't have to do anything for a bit. The investigator will then turn around and, let's say you were harassed in your workplace. Now the investigator is going to start pulling who owns the business. What's this business license number? They'll go and figure out, depending on the situation, maybe they'll go and interview, the business owner. Maybe you already have enough evidence because you have text messages or something like that. Just depends what the situation is. And then immediately we try to go to a resolution conference if it seems like the right thing to do. Recently, there were some extreme cases where it was bordering on sexual assault. We didn't feel like we had any need to go to a resolution conference there. But on a lot of these cases, especially about service animals, it's oftentimes a business owner who doesn't know what the rules are. So usually we'll sit everyone down and we'll say, hey, look, here's the evidence we have. Here's the law. And then sometimes people will go, wait, oh, that's the law? I broke that law. Oh, no. And then we'll say, okay, well, then let's sit down right now and try to fix this as is. What does it take for either side to feel right? We're going to make sure that they change their policy. They know what the law is on the respondent side, the bad actor, and on the good actor side, we want to make sure that they get what they need to make sure that they're made whole, right? So if you're fired because of a discriminatory reason, we want to get you back pay, right? If you were denied lease of an apartment, we want to get you the next available apartment and cover your expenses for however you've been living for that time since. If it's a discriminatory city regulation, well, we want to get that off the books now. Whatever makes sense for the situation. I can't get you $1 million. If you're someone, well, okay, well, technically I can. I've gotten pretty close to $1 million, but that has to be back pay. But if you call me and you say, hey, I was fired from my job at Arby's, chances are you're not going to get $1 million. You might get, the back pay from the amount of time of when you were fired to when you started in another job. But I do work for free, so that's a benefit too. We also, for the record, have a lower standard of evidence than a private attorney. So if you bring the same case to a private attorney, they may not be able to get enough evidence to prove that. They may say, well, now it's he said, she said, and now I can't do anything about it. I love he said, she said cases. Those are absolutely within my evidentiary ground. I say, yeah, it kind of sounds like this happened. Let me take this case and let me start subpoenaing. And then I can get more evidence as I'm going. A private attorney can't do that. Additionally, a private attorney often wants you to put, down money as basically a retainer. I don't take any money, so you can come call for me with whatever. Occasionally, people will have us do all the legwork and get all of the investigation file. And they say, wow, I have a really strong case. I want to go to a private attorney now to get my $8 million. I'll say, yeah, here you go. Here's your investigation file. Now, when you talk to an attorney, you're not just some random person off the street. You're some person with a big rubber stamp on it from the state government that says, yeah, here's a case that looks like it's great. And they'll take you for nothing because they know it's a guaranteed payout. And they don't have to do, 60% of the work because we've just done it. So a couple different ways that you can use our agency. You got some, Delight?
I do. So I have kind of a case scenario.
Yeah.
So Catherine says, what about when it's messy? For example, when someone with a disability cannot get an apartment, they believe it's about their disability. However, the property management company states it's due to lower income or all public benefits. Is that grounds to come to you?
I mean, I always tell people come to us if you have a suspicion, because the worst thing I can say is sorry, I can't help you. But the best case scenario is that I can fix the problem and it won't cost you money. In that situation, that sounds like something that it could be, right? Very rarely do I call up, someone who is allegedly, racially discriminating against someone, and they would say, "Well, yes, I am racially discriminating against someone." They always say, "No, no, no, no. It was because of work performance. It was because of, maybe they were too experienced for us." They like to use euphemisms, things like that. Same case goes for housing applicants, right? And I'll say, okay, prove it to me. Let me see what the income is of all of your other residents in this situation. How many of your other residents have similar disabilities? You know, uh, Tagline on this though, if you are on state controlled income, like if you're getting a, Section 8 like voucher, if the renter, if the landlord does not move the date of rent to match when you'll get the Section 8 housing voucher, this is a common problem where they'll be like, well, I get my voucher on the 5th, but rent is due on the 1st. So I'm always owing the landlord an extra $50. If the landlord doesn't move the date to the 5th, that is discrimination on the basis of disability in the area of housing. I have a big, thick load of case law to back that up, and I will take that case in a heartbeat. So just, for the record, if it applies to a case, I didn't know if I heard the full situation, but that is something we can look at and something that I've taken those cases on. But bring me the messy cases. Almost never do I get this. If it works and people realize, oops, I made a mistake, it doesn't even get to my desk usually. But I still have a job, and that's because the messy cases work their way through, and we usually end up winning the messy cases. I'm handling ones on, people saying that, oh, that this was this employee was coming on to me, and I have to work through all the, phone records and the text messages to make sure that that's the case. If someone says that they're doing it for a non-discriminatory reason, that could be the case, but I'm going to really need to be convinced that that was what is at issue. Now, in the same vein, people come to me all the time and say, I was fired because of my race. I pull their, record, and they were arrested for beating up their boss. I'm like, sorry, that's you actually probably got fired for beating up your boss. I can't take that one. But if it's he said, she said, come to me basically anytime. I love to latch onto those and look through those. That's what I'm here for. My job as a state agency is basically to take the cases that are not strong enough for you to just hand to a private attorney and they'll say, "Oh, yay, free money," but probably still include discrimination. That's the niche I sort of fill. So definitely bring me messy cases.
You're saying, to just saying it another way, if a care coordinator has an instinct that their clients being discriminated against in those different environments of employment, housing, finance, to just don't overthink it, just connect them to Alex. And one of the questions that is being asked is there a time frame from the event that someone should contact you?
Yes.
What if this happened 10 years ago or it happened 10 days ago? What's your time frames?
Yeah. So first off, I would say yes to the first part, which you said. If you have something, don't overthink it, send them to me. I'm not saying I'm a miracle worker. I can't work everything. Not every case is going to work out. But what I can say is that, at least to me, the cost benefit analysis is that you sink in the time of a phone call. And the worst thing that happens to you is that you had to make a phone call. But the best thing that happens to you is that I can solve this problem that you think is discriminatory, right? I can get something. I can get a housing unit. I can get back pay, whatever the case is. I can get a change in employer policy. We can work on fixing that problem, and I have some muscle to do it. On the timing issue, I am limited to 300 days from the discriminatory event, right? Now that can change, and sometimes it's going on forever, right? So in cases of harassment, oftentimes it's an extended period. I would need something from a date where the harassment, allegedly ended, which is typically, and I quit. So long as I can get it within 300 days of that, and you make the complaint, I can go forward with it. If 300 days passes while we're working on it, that's not a big issue. We can still work our way through so long as your foot gets in the door within 300 days. I can latch onto that. Which is, again, people are saying 10 years, and I hate being this person, but this is why I'm love to do these sort of events, is that not enough people hear about us in the state. People don't know that we're a resource and here for them. I go to, oh man, every single state fair. I'm in, down on the peninsula. I was just at ADAC. They send me everywhere, so that I can be like, hey, call me. And my information just doesn't get out as much as I would like. And sometimes people are like, oh, I wish I knew about you 8 years ago when this thing happened. And I'm like, I wish you did too, but I can't take that because too much time have passed. You're out of my statute of limitations. But again, the gold number here, 300 days from the instance of a discriminatory event. And that can be still going on or something like that. So always feel free to reach out.
So a follow-up question, I guess.
Yeah, Kat.
If the care coordinator and the person are not sure if it's a discriminatory,
reach out. I mean, like I said,
reach out to you and you guys could talk through it and figure out.
Exactly. And sometimes, people call us and it's a suspicion, and they're like, I'm not sure. I got this rejection email, but like I felt like he was really weird whenever I, was on Zoom for the first time, and then the tone shifted and they realized that I may have some kind of, disability or something like that. We take those cases and we say, I'm not going to lie to you, those can be harder cases because it's always easier if there's something more concrete, but sometimes we can make those cases work, right? We can look at and say, well, has this person hired anyone with a disability before? Is this a massive company that's just systematically breaking them out? Did they ask some sort of weird questions? Can I see your notes that you wrote down after, you took the interview? If not, why don't you have those? If that's included in corporate policy, we can look through and sort of say, tell us what's up. We're meant to be sort of these, what's the word, guard dogs on this sort of thing.
Right. And do you have to hear from the person, or would that have to, if they have like a legal rep, or could that be a care coordinator that calls you?
I need to have someone with legal representation, so that, if you're just someone who is in the room, I can't say, hey, you can't call me and say, hey, my friend got discriminated against, and can you take this case, unless you get your friend to reach out to me. Your friend can be there and help out and help translate, or help them hold up the phone, things like that. But I do need to at least hear from either the party that the discrimination happened to, or someone with some form of legal representation relationship, whether that be a guardian or you guys are the people in the field handling these sort of care coordinator things. Your relationship with your clients better than me, so I'm gonna I'd have to double check exactly who is filing what, but if you've done it for similar things, you can usually come to me.
Okay. We do have another case example where we're trying to think it through. And it's, how about a housing situation when a landlord won't rent to someone with a disability who's also a registered sex offender?
That's, gonna be a interesting situation. I am actually currently representing a sex offender. That sort of comes with the territory. I would have to see that when, if I can find proof that is because of a disability, right? Maybe if they say in the email and they're like, hey, we think this is because of, we don't have a ramp or something like that, then I can latch onto that and work on that.
Sorry about that. We're playing Whack-A-Mike. Okay. This is just a quick reminder, friends. Please mute yourselves. Kat and I are hitting mute in the background.
Okay, yeah, that's fine.
Yeah, so I think, just like to frame up, a lot of these scenarios, I like seeing you guys are really thinking, are really engaged. But I think the big key here is that, like, Alex, you could have two scenarios happen and Alex would have to sift through your case, and one might have grounds and evidence and one might not. Your best approach is to show up. Another and ask. And another question is like, what about being a single mom? That kind of comes into that relationship one
Yeah.
again.
I
Yeah.
can handle some of the single moms is covered, absolutely. That's marital status, that's parenthood, pregnancy sometimes gets involved in those. I would have to see exactly what happened for it to be discriminatory, but like, you know, could someone not hire a single mom because in the hiring manager's mind that, you know, says something negative about her? Yeah, that's discrimination in the case of employment on the basis of your marital status or parenthood or both. And in that instance, you can bring that to me and I can rep that. You know, there's certain situations where maybe I can't touch that. Keep in mind, I don't have coverage over government practices on marital status or pregnancy or parenthood. So sometimes people come hit me up and about like, you know, the child support system is biased in some way. I'm like, maybe it is. I can't take that as a case on the basis of marital status. You know. Now let me keep going real quick just to run you through. You know, we have an investigators. They'll run through. They'll look into everything. It'll come down. If it looks like there's enough evidence, our barrier is something called substantial evidence. It's if you think about, you know, you have to be beyond a reasonable doubt to get someone convicted for like a murder or something. That substantial evidence is way down here. It's one of the lowest evidentiary barriers that there is. So always come to me and I can look into it. And if it looks like something happened, then again, we'll sit down and do something called a conciliation. This is usually about when both the opposing side is going to get a lawyer. We're going to work through an agreement. Typically, if I'm working a conciliation to find a settlement agreement and the side is willing to work with me, in cases of employment, especially, I'm looking for three things. One, fixing the problem with the person that filed the complaint. That could be back pay, that could be training, that could be a letter of recommendation to a future employer. It just depends on the situation. Two, I'm looking to make sure that we can fix the problem. That if it is, you know, this is something where internal policy at a company doesn't correctly address this, I want to see you change that internal policy. I want to see exactly how you change it, and I want to sign off on how you change it. And if you change it wrong, I want to say, no, try again. I need you to be in line with the law. And three, we want to make sure that that gets out to the employees and the parties within the company that they know that this change has happened. So usually I'll require some form of training and mass update that like, hey, the handbook has changed. Now we want you to do this. Just sort of basic stuff like that. I want to, oh, did I miss something? No? Okay. I want to run you through some of our big moving cases right now, just because I think this is something that people see a lot. Service animals has been a big area for us and it's really ballooned in recent years. So quickly, I need to just lay out, there are a few different categories of animals, but I want to talk about service animals and emotional support animals. Sometimes these get conflated and they have different protections under the law. So service animals in the state, first off, they have to be either a dog or miniature horse, right? Now, I don't think I've ever seen a miniature horse as a service animal in the state, but some people use them for, you know, to like pull around wheelchairs and things like that, open doors, things of that nature. And it has to be trained to perform tasks to assist a person with a disability. That's all I need. They do not have to be licensed. You do not need to have documentation. You do not have to be, you know, have a vest on, right? All I need to have is for it to be a dog or miniature horse. It has to be trained to do a task, and that task has to be in the service of someone with a disability. Okay. These service animals should be allowed to go anywhere that someone with a disability should be allowed to go, unless the dog is not in control. So like a business can always ask your service animal to leave if like it's attacking someone or if it's peeing or pooping on the ground. Those are the two biggest things that I say, no, sorry, they could have actually asked your service animal to leave in those instances. Or if it would pose a significant risk. Business owners love to get a little silly with me on these, and they'll be like, well, actually, I have an employee who's allergic to dogs, or I'm actually scared of dogs. That's not significant. You still have to let a service animal in, even if you may have some fears of allergies or fear of dogs. These are things like the only case I can think of is we had where someone was in something pretty close to an iron lung, and the possibility of pet dander would like literally threaten this person's life. We said, hey, we can't let a dog be in there. Sometimes you see them in like kayak rentals and things like that, but if a dog can be allowed in, you're supposed to find a way to get a dog in. Service animals can only be asked two questions by business owners. That is this animal needed for a disability? And what work has this animal been trained to perform? If they require you to answer anything else to let them in, now they're committing disability discrimination. And you can come to me and we can get it right. On the flip side, emotional support animals can be any animal, and it is not necessarily trained to do a specific task, but they provide some form of benefit for someone with a qualified disability. You know, think about someone with depression and they have, you know, some form of, you know, a warm, fuzzy animal that makes them feel better about life. Absolutely covered by an emotional support. They have no protections for places of public accommodation. However, here's a big area where they do have protections. Housing. Under the Fair Housing Act, a landlord or other housing provider must make a reasonable accommodation for an emotional support animal. All right, if you have an emotional support animal, let me say it in a different way, your landlord needs to let that be in your house, so long as you have to require the proof, right? You have to prove that the renter has a qualified disability. That might just be a letter from a doctor is the best way to do this. If you get a letter from your doctor that says, hi, my person has a qualified disability and having an animal would benefit them, you give it to a landlord, that should be enough for the landlord to say, great, let's get your animal in here. All right, they cannot ask for your full medical records. Some people love to try to do this. No, that's going to cause you an issue, and now you're putting too great a burden on people with disabilities. I skipped over in part 2 is that there is evidence that an animal would help them with this condition. This is very loosey-goosey because you can almost always find a reason to tie it to something. The accommodations must only be reasonable. Basically, this requirement is in there to say, like, okay, you can get something in here, but if it would be like really out there, the landlord can shut you down. You know, if you want to keep 2 llamas in a, you know, studio apartment, that's going to run you into trouble. But if it's a dog or, you know, 2 dogs, usually that's going to be covered. And here's a huge one that they always try to do: no pet fees. If you have an emotional support animal and it is in your place of housing, charging you a pet fee is charging you money because of your disability. Guess what that is? Disability discrimination. They try that, send them to me, or better yet, call here and I'll sue them. And we can work either way of that case. All right, you have something else as I'm talking about service animals, or else I'm going to move the pregnancy. All right, moving the pregnancy.
No, we are just loving the miniature horse idea.
Yes.
That's didn't know that. Love it so much. I didn't.
Yeah. So those are the
That's
only
cool.
ones
That's
that are
awesome.
technically covered as service animals. There is also sort of a different category in between here called alert animals that have a bit of like halfway protection. That can come with, you know, greater, people can ask more questions. And basically, if you have an alert animal, you're supposed to have some kind of documentation on you, unless that alert animal is a dog. But I do know that there are people that have alert animals where it's like a pig that smells for diabetes, you know, things like that. And we also sometimes see ones for dexterity issues. I've seen someone who had a little capuchin monkey that they couldn't use their hands, and the capuchin monkey like opened their pill bottles for them, and you know, press the buttons to open the door and stuff like that. You're almost always going to need to have paperwork for that as you're going around, because any business that sees you, you know, with a monkey on your shoulder may go, whoa, what's that situation? You know, it's sort of just balancing what is going to be a burden for, you know, the public and what is going to be a burden for people with disabilities. In Alaska, we really say almost never should someone be required to carry around a piece of paper to say that they need their service animal in, right? Unless it's something funky, like I said, like a monkey or a pig or something. If it's a dog and it's been trained to do a task, that's it. I don't need any pieces of paper, and they should be able to go just about anywhere you can go. All right, I want to talk about the Pregnant Workers Fairness Act because this was a recent change and it's pretty huge. So the goal of this was basically to maximize the opportunities for pregnant employees to still work in the workplace, right? Let me tell you, this all basically almost goes back to one situation which was super common before it passes, right? You apply for a job, and as you apply for a job, they sort of have like key job descriptions or components of a job, right? And what is one thing that it doesn't matter if you're applying to be, work, in a bakery, if you want to work in an office, if you want to work wherever, is they'll say at some point, occasionally lift 20 pounds, right? Or they'll say, occasionally have to climb stairs or a ladder to be able to reach something off the top shelf. And then we would have cases where there would be employees who become pregnant and basically get some kind of, your doctor will very early on say, hey, we don't want you to lift too much weight. We don't want you, you may experience vertigo. We don't want you climbing super high to protect you and the baby. You tell your employer, and your employer says, oh no, well, it's actually a key part of your job description. I'll need you to sit on unpaid leave until you have that baby. No longer is that the case. Under the PWFA, even a key component of your job, if it can be reasonably removed, is a reasonable accommodation under the statute. Let me get into exactly what it says because this is a little loosey-goosey. But the PWFA, I'm going to read you, this is basically what's on the EEOC website, requires that an employer provide reasonable accommodations to an employee or applicant's known limitations relating to arising out of pregnancy, childbirth, or a related medical condition, unless said accommodation would impose an undue hardship on the employer. Now, that's a lot of kind of gobbledygook, but what I want to take away, the big parts of it are, again, core job functions under this law can be paused for a pregnancy, right? Now, sometimes the entire aspect of your job probably isn't great to do if you're pregnant. I've seen cases where, it's someone works in a factory that produces every chemical that's bad for a baby. That's not going to be a great time. However, depending on the case, and if there are options for you to even swap jobs, that is still allowed and could be a reasonable accommodation that you should be given for the duration of your pregnancy, right? So I've seen cases where I think this person was like at like an Amazon warehouse and they're like, hey, I can't lift these heavy packages. When Amazon did not put them on basically light duty for the duration of their pregnancy, Amazon lost a pregnancy discrimination suit, okay? Where so long as there was an opportunity for them to, instead of having to lift giant boxes, which would probably happen most days, but they were able to be put on a circuit where it's like, we want you to deliver, the little letters containing, I don't know, the little like child protector things that go in outlets, light stuff like that. Then failing to do that could be discriminating against you on the basis of your pregnancy. There's also a few that are listed as per se discrimination. So employers always have to allow requests of pregnant employees to sit or stand differently from what they are. So if you're a cashier and you get pregnant, you have to be allowed to sit down. I don't know why every supermarket wants to fight me on that. Just sit down. It's a cash register. If you want to have extra water on you or take additional snack breaks, they have to allow these sort of changes to your workflow, and they cannot require documentation of that so long as it's obvious that you're pregnant. Pregnancy discrimination also includes conditions relating to pregnancy now. And so these include things not just like the pregnancy itself, but symptoms that come with pregnancy. So think like morning sickness. These include conditions that you may have had beforehand, but now are worse with the pregnancy. So say someone suffered from migraines their whole life. Well, occasionally when you get pregnant, those migraines get a whole lot worse. Allowing time off for, those sort of worsened migraines is going to come with an accommodation for one's pregnancy. And include things that are not like, relating to the pregnancy themselves, but could be, sort of associated with it, right? So this includes IVF, fertility treatments, all sorts of things like that. Technically, it can go on for an indeterminate amount of time, but the law gets a little funky. We had cases with what is that called? A lithopedion, where there's a calcification of a fetus that gets discovered like 20 years later. Technically, you have to let someone have time off for that because of pregnancy discrimination, but that's going to be a weird case, and that's going to be handled, kind of funkily. So I don't want to give you the whole say what that's included, but just to be clear, these are broad protections that are now included in what pregnancy discrimination is. All right, I think that's all the points I wanted to get to. So let me turn to what y'all have. I know I've been talking for a while. I swear I wasn't trying to jabber on, but
So, a couple of things in the chat. One of
Mhm.
them is going back to service animals, and
Yeah.
the ask is the flip side.
Okay.
What if an animal causes trauma to another patron of a business who's disabled? I know someone who avoids public places out of fear of dogs in those settings.
There can be, locations where you don't have to allow in a service animal, but usually those are going to have to be private places. If a place is generally open to the public, you have to allow people with service animals access to that location. Now, I'm not saying that if you are, working as an employee and you have severe trauma with dogs, if you want to work something out with your boss, that's like, hey, when a dog comes in, I'm swapping with you or something like that. That's a-okay. We're not going to be mad, but it will count as disability discrimination if you don't allow someone to enter a place of public accommodation with a service animal. And in those defenses, fear, traumatic experiences, allergies of dogs are not defenses to that. That's just the way the law is, and that's what it looks like it's going to be for some amount of time. I've heard a lot of people, have complaints or thoughts on that, but that sort of is what the ADA prescribes. Did that answer your question?
Yeah, and I think that, in our work, one of the things that we can do is you're welcome to bring this kind of case to our office hour, and we can think of different techniques we can use to make sure this person is included in environments where there might be service dogs, and how we can support them to build tolerance to experiencing those encounters, because we don't ever want anyone distressed. So feel free to come staff that, because we would always be happy to talk through the dynamics and staff it. Next question. So how is undue hardship defined? Financially?
Yep.
Systematically? Like, how does that work?
That's one of the legal terms that it's a bit hard to exactly put your on, but basically it's, would it cause some form of extreme burden that is defined. We look at finances, we look at procedures, we look at what would have to change. It's really a case by case basis on what that is, and two accommodations could be different for different settings, right? So what would be an undue hardship to, some mom and pop where you're the third employee may not be an undue hardship for, a multinational corporation. Here is one great bit of advice, though, is that if you have done it before and it was okay, you cannot argue that that's an undue hardship to me, right? We have cases where, like, hey, this guy broke his leg and now isn't able to carry a lot of weight. You made the changes for that guy. And now, if you're not making the same changes for someone with a pregnancy that is looking for those same changes, now that is definitely discrimination. And I know that the accommodation is not an undue hardship because you've done it before. So I apologize for sort of the lawyery answer, but that's the lawyerly part of the law.
No, that's great. And you know what? You've done a great job of lowering the legalese down a bit. We appreciate that, and making a real life chat with us here.
No, I didn't mean to offend or anything. I'm just,
No,
a lot of
you're
these
doing
are
great.
very
You're
case
doing
by
great.
case. Lucy
And a
Goosey.
lot of these topics are really complex. Like, let's just
Mhm.
take into consideration that they're incredibly complex for many, many reasons. So, and we're all very aware of the complexity of humanity and those dynamics. Can you tell us a little bit about the links that you have on the screen right now? And
Yes, I just have these up here. If there's something that you'd be interested in, I have a series of guidance documents. I have YouTube videos covering individual topics more in depth. That's on the Commission's website, which is humanrights.alaska.gov. They have, so we have, previous cases that have gone public. You can see our annual report, which has, anonymized versions of all the cases that we've taken. It has data for, demographic employment across the state. And then eeoc.gov. EEOC is the Equal Employment Opportunity Commission. That is a federal agency that broadly does what we do. They have guidance docs on their website at eeoc.gov/eeoc-guidance. I will flag that right now, some of those guidance documents are being reviewed for compliance with a recent executive order. So that could change what is on there, but are things on there to answer some questions, maybe just not everything that there was 2 months ago. And our website, humanrights.alaska.gov, tells you what the state law is, what's compliant with the state law, and that's not up for debate as far as I know. So I know that can be a bit confusing with the speed at which the political climate is moving right now.
thanks. Yeah, so that is definitely things folks are
Yeah.
trying to navigate as they're exploring it. So there's the
Oh.
link that I dropped isn't working, so I can try again. I probably
Oh,
put
is
it
it causing
in
you
wrong.
problems? If not,
It
you
might
can
have
just look
been
up
me.
eoc.gov and it'll take you to the front page.
Oh no, it was probably me because
The human
was
rights one, I'm
typing
looking at it right now, has 4 W's in it because I am quite foolish. So that's probably why it's not working for you.
Hold on, let me
Didn't
get it
realize
from
that
the
until I looked at it
source.
right now. I am so sorry. Humanrights.alaska.gov also takes you there. You can also reach out to us at our front desk at 907-274-4692. You can scan that. It'll take you right to our front page, humanrights.alaska.gov. Whatever form works. You can walk in. Our office is in Anchorage. We're right across from East High. You can send us mail. I think I still have a fax machine. Please don't fax me. I'd have to remember how to use that. But whatever works, we're here to take the case and let us know how we can help with this sort of stuff. But I didn't want to cut off questions. Is there anything else? I know I don't want to keep any of y'all too late, but
we're really on the kind of wrap up, but there are some questions related to the DEI executive order, and about if whether there'll be groups that will be affected or cherry picked out of those groups if there's like anticipation of that. So I'm not sure if you're if you see that.
But my agency, that doesn't affect us because we're a state level and those are federal level executive orders. B, you can people define DEI all sorts of ways, but I don't think what we do has ever been considered DEI. You can come to me with a case of discrimination against a majority group. I prosecuted a case a bit back where there was it was an Asian restaurant, and a young white woman applied to be a waitress there, and she was told you don't fit the aesthetic that we're trying to set, and so we're not hired. Right now, what that was discrimination on the basis of race. It was discrimination against a white person, but it's discrimination nonetheless. We still took that case and we won. So even if that's not a traditionally disadvantaged group, you can come to me with these sort of cases. So I don't think that I know that the executive orders have not affected us because we're a state agency, but B, even if similar executive orders were to trickle down to the state, from what we're seeing right now, it doesn't look like anything will radically change us. If that changes, we will put that on our website. We'll put that every which way we know. But as it's sitting, I'm not doing anything different from what I was doing a year ago, if that makes sense.
Yeah, it does. And I just want to express gratitude. This was a great presentation from you, Alex. Like, we really
you.
appreciate the time and just the breakdown on this topic. You're getting some shout outs in the chat out of appreciation. And I just
Love
really
to hear it.
want to encourage you, care coordinators. You are making contact with vulnerable populations. People are telling you the things that they encounter. They don't always know they're being discriminated against. They don't always know. And you are a guiding force in many people's lives, and you may shine a light on something and say, hey, that wasn't right. Let me hook you up with my friend Alex. And you can explore it, because that's what we want. That's what SDS services are about as well. We want inclusion in the community. We want people to be included. So that is the heart of, the goal here of connecting you with the Alaska Human Rights Commission. So thank you all. If you're ready for your certificate, you got to give us a couple of days to cook it in the training academy. Okay, give us some time to cook it in the academy, and then you can go in and print it. Until then, we really appreciate all that you do. You guys are amazing, and we'll see you next time.
Thank you.
Thank you all.